The Full Melt Show is intended for a mature audience. It contains adult themes, adult content, and sometimes adult language. Listener discretion is advised.
It's the Full Melt Show.
Full Melt.
Are you high? What are you talking about?
Oh, I don't even know what happened there, but here we're going to do this way anyways, because I just don't know what happened. Welcome to the Full Melt Show. It's a crazy day here in Michigan, and we got audio here. What's going on? It's just driving me crazy.
It's the Full Melt Show, a marijuana discussion about news, culture, and entertainment. TheFullMelt.com. It's your backyard. It's celebrity interviews, talks with politicos. Plus, your calls are on the air. Download the Full Melt app, free at the Apple and Android app stores. With your host, Steve Green, the Full Melt Show.
Okay, so that's where we're supposed to be. I removed an old piece, and something went wrong. Something definitely went haywire at the beginning there. I feel a little more comfortable now. Smiling, happy days. And we have a lot of people already trying to call into the show because of today's subject. If you're calling into the program, the number here is 248-278-8067, 248-278-8067. And I'm hoping that this is Wendy. Is this Wendy? Hello? Nope, that's not. That's definitely not Wendy. That's not Wendy. That's not Wendy either. This would probably be Wendy. Is this Wendy? Hello? Can you hear me?
Yes, I can hear you.
Okay, there's Wendy. It's already been a nightmare, Wendy. What's going on?
I don't know. It sounds like you're doing typing in the background on this end.
Yeah, we don't want to hear about all that. I don't know. I don't know what, it is what it is. Nobody's typing anything. So
okay.
I have no idea what the hell just happened on the beginning of the show, but it's part of this is getting used to doing the Facebook thing. So on the program today, we are talking to attorney Josh Covert, assuming that, normally I'm setting this stuff up during a different part of the show here. And I'm completely thrown asunder. So I don't have Josh on the phone yet, but I should probably call him up. The problem, Wendy, is that that's difficult to do from where we're at here. Let me just see if I can dial him up. So why don't you set up what happened today? Without giving, just tell people the background about the story.
Okay. Well, now, I did briefly read this case, and I have to admit that I did not read it as much as I wanted to. Wait.
So there's something terrible happening with the this phone line.
Yeah, it's horrible. Let me try calling back. This is terrible.
Yeah, there's something with the internet going on tonight. I don't even know what's going on. It's not stuff here. It's just bad luck, is what it is. Because I'd let her just go on, but it'd be just terrible. That audio, it just makes you want to jump off a bridge. That audio. So today, Josh Covert, I'm gonna see if I can go ahead and get him on the line here while she's calling back. Is she a slow dialer? What's going on here with the slow dialing? Wave faster fingers, Wendy. So So I'm just going to do this myself, Josh. I suppose Josh is asking me a question on the Facebook here, and I don't have a way to plug the phone in that he's asking me the question on into the soundboard. So let me just do the stuff that normally we'd have done the show today at 7:00 Eastern. Wendy, are you there? Can you hear us?
Yes, but the line is bad again.
The line is bad again.
Yeah. Is this any better? No, I still hear it. I still hear a lot of just bad noise.
I just don't even know what to say. Hang on a second. One of the things about internet radio is that you never can tell what's going to happen. See, Wendy's coming in over an internet line. It's a telephone line, but there's something going on with it. I'll tell you what. Let me try you back at your number, Wendy. Just stand by.
That'll work.
All
okay.
right. No, wait. Are you there? Oh, there she goes. I can only dial out from one place. And maybe I'll have Josh call it, but then he'd have the same problem with that stupid thing. I have no idea. You know what I'm going to do? All right. Let's just try this. Typing it in. Let's see if Josh has any better luck. And I'll try Wendy on her line here and see if we can get Wendy up. If you want to try and call 248-278-8067, I don't know if that's going to do you any good or not, but we're about to find out. Just going to call Wendy back on the other studio line. Normally, we've got a phone screener here that sets up and does this stuff, but it is what it is. No one today. Do 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 0 do 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 do. See if Wendy's on a better line this way. And we got one ringy dingy. There you are, Wendy. Let's try and put you on this way. Stand by. See if is it any better this way, Wendy?
Yes, it's wonderful this way.
All right. Now, I'm afraid that we're going to get Josh on the phone, and he's going to have the same problem that you did. I don't know.
Well, then you'll just have to bump me because Josh is our star for the moment.
Well, Josh is the guy, but let's see if I can. I've got no way to call out now. I can't call him on that other phone. That's what I.
Do you want me to have Theo call him?
No.
Oh.
Yeah. So. Let's just see if Josh calls in. He's got the number there. I just don't know that he's seen the message yet. Normally,
okay.
I call him.
Well, on a break, why don't we try calling him? You can hang up with me.
No, I'm just going to do this. I'm just going to do this and put him on the speakerphone on Facebook, see if he'll answer the Facebook.
Okay.
Hello?
Hello?
Hey, Josh, it's Steve Green.
Hey, Steve.
So, Norm, I've got you on the Facebook phone on the speaker, and we're actually on the air. Could you call the number? I texted you a number. Could you call the show number? See if.
Yeah.
I'm hoping that works out better this way.
Sure.
All right. Thank you.
I'll call that number.
All right.
Yep. Bye.
Bye. It's 248-278-8067. Driving law in Michigan today, affected by the Court of Appeals. Josh, the attorney of record on that case. And also, I would assume the man responsible for writing the brief on appeal. So here we go. Let's see. I'm going to see if I can pick him up here if this is any better. Josh, are you there?
Yes. Hi.
All right. Is the phone line terrible? Are we having problems with the phones? Is it okay? Can you hear me all right?
I can.
Yeah, there's something wrong with that phone. Oh. All right. We might have to do it this way. So, I'm going to go ahead and call you on your regular number there, Josh, from a different line, one that I know that is not doing this, and the other lines we're going to have to reboot during the break. Wendy, we're going to have to make you go goodbye and then call back after the first break. Does that work? Will that work for you?
Hasta la vista, baby.
All right. Thanks, Wendy.
Bye.
Oh, good Lord. All right. Did you hear the plan, Josh? Could you hear me okay to hear that? All right. I'm going to call you back. I'm going to call you back from another number.
Thanks.
All right. What a nightmare. Terrible. All right. What's the Josh number again? Here we go. Do we have a dial tone? Yes, we do. Oh, good Lord. Oh, wait a minute. Don't tell me that I was... Let me see if I got him this way. Oh. You know what? It's just killing me. If I had a break to go to, you know what? That's what I'm going to do. I'm just going to go to break and do it early. So bear with us, people. This is terrible, terrible, terrible. This never happens to me. Never happens to me. I'm just going to play the break early. Here we go. So I'm going to get crap together here as if the beginning of the show was actually the beginning of the show. You got a Tylenol for me? You got a dab? Can you send me a dab? Because a dab would be a good thing. I'm just saying. The CBDs aren't going to be helping right now. The CBDs are not going to help. I need a full dab, and nothing more will do. But a little dab will do. Back with the real interview and the beginning of the show after this message.
You're getting the full melt.
Your pets aren't just animals, they're members of your family. That's why we are excitedly wagging our tail about our hemp-based product that caters specifically to your best friend. Hemp oil drops are great for aging as well as active dogs and cats, and really all kinds of pets. Hemp well drops are made from virgin, cold-pressed organic hemp oil. Our extraction process ensures the highest quality oil for your pet, with superior taste, smell, and nutrition. We hold ourselves to the highest standards, never using heat, chemicals, or preservatives in making our hemp oil products for pets. Pick up a bottle of Hempwell drops today at select retailers or online at hempwell.com. Hempwell, hemp health for pets.
If you missed the last Full Melt show,
you missed a lot.
Yes, sir. We are just here to get you qualified, okay, for the lower interest rates.
This is a Visa card.
Okay, it's a Visa card, starts at 4, right?
So why do you need the numbers off the card?
I was going to let you know, like, what is your new interest rate going to be and what you qualified for, okay?
Well, wouldn't it be a security risk if I was to give my card number over the phone?
Like, sure, we are the ones who send you the billing statements every month.
Aren't you really just a liar? Aren't you just lying about this? Aren't you just trying to steal my credit card number? Oh, you are, you little piece of shit. You're a little fucking liar, aren't you? You're a little foreign piece of shit, aren't you? You're a little foreign fucking puke, aren't you?
That's what you are. You fucking piece of shit.
Oh no, you get to suck my fucking American dick, you foreign piece of fucking shit.
There you go. That's how you do that.
Imagine a world where patients can use marijuana like any other medicine. The Marijuana Patients Organization challenges the status quo by helping our neighbors to enjoy a better quality of life. Visit the MPO at marijuanapatients.org and enjoy informative articles, engaging debates, and information about treatments, doctors, and dispensaries in your area. Over 50,000 people have registered at marijuanapatients.org since 2010. Join us at the Marijuana Patients Organization today, marijuanapatients.org.
When you need legal help, you don't want to guess at who's standing next to you in court. And when it comes to a medical marijuana defense, it's even smarter to partner with a lawyer before you need one. Based in Royal Oak, David Rudoy has a proven history of not being afraid to take your case all the way to the Supreme Court and win. Find the law offices of Rudoy Law
at rudoylaw.com.
rudoylaw.com is a quick reference on your rights concerning Michigan medical marijuana
and up-to-date news.
That's RUDOI law.com. Call 248-935-9074 now and talk about your legal needs, because at rudoylaw.com, we don't just stand up for you, we stand up with you.
Wish your skin could bounce back like it used to? Neutrogena Hydro Boost Water Gel instantly quenches skin to keep it supple and hydrated day after day. With hydrating hyaluronic acid, which retains up to 1,000 times its weight in water. This refreshing water gel plumps skin cells with intense hydration and locks it in.
For supple, hydrated skin that bounces back.
Hydro Boost from Neutrogena. See what's possible.
And now, a Planet Green Trees flashback.
That is the paradox. You can't make this, the civil employees rebut the presumption, right? The state just gave $8.5 million to this administrative agency to implement. I mean, the concept there is a little offset.
The police still seem to be involved in it.
Nothing takes incentives away from police. In fact, it gives them more fish to shoot in the barrel.
Right.
The police are literally the regulatory agency for the entire program.
And why is that?
They needed their cut.
They're the only ones knowledgeable and responsible enough to handle it. This major public health and safety issue.
Don't miss the Planet Green Trees show, Thursdays at 8 Eastern on Spreaker. It's the Full Melt radio show. All right, I think we got everything fixed up now. Oh, good Lord. I didn't realize that the phones would need to be rebooted to keep them from doing that. Welcome back to the show. Let's see if we got Josh on the line. Josh, are you there?
Yeah, hi.
You can hear everything. It sounds good.
Sounds great.
Wendy, are you there?
I am here.
And it's still crappy, isn't it?
It's bad.
I could just tell
it's so bad.
I can tell there's something going on with those lines. So at least they're functional for the purpose of getting a question in or two if people want to call.
All right.
So I'll let you call. Do you have any questions for Josh, really quick? Because I started to let you set it up. Why don't you go ahead and set it up? At least I can give you that much.
Are you talking to me or Josh?
I'm talking to you. That's good Lord.
Oh, you want me to set up the case? Okay, here's the case. From what I understand, is that there was a law passed after the Medical Marijuana Act that said that you had to transport medical cannabis in the trunk of your car, or if you didn't have a trunk, out of reach from the passenger cab area.
Right.
Okay, because not everyone has a trunk. Some people are in a minivan, some people, whatever. They have a truck, blah, blah, blah. So the argument was, well, the Medical Marijuana Act, you can't make any laws to amend that or interfere with it or the rights underneath that act.
Right.
Okay.
You know what? The audio, Wendy, the audio is so bad I can't take it anymore. So
mine's good now.
Yours is good. It sounds like you're talking through a buzzsaw.
Oh, my God.
Yes.
Yeah, it sounds like the printer's going on.
Yeah, there's something. Yeah, it does sound like a printer. Now that you mention it, it sounds like a dot matrix printer.
A dot matrix, yes. We're in the matrix, people.
Oh, God. I just want to jump off a bridge. All right, I'll finish setting it up, Wendy. I'm sorry. Let me dump this out. I don't know why that phone line's not working. I'm glad we got the one working for Josh. Let's move on.
Okay, no problem.
All right. Terrible stuff. It's just mind-numbing. All right. So the idea is you're traveling in Michigan, you've got marijuana in your car, you're a patient, you're a registered caregiver or patient in the state, and they crafted a law after the Medical Marijuana Act was passed that said, and it's not amending the Medical Marijuana Act, it's just a new driving law that says if you're a patient in the state and you're driving with your weed, you got to put it in a box somewhere out of the reach of the passenger compartment. Am I somewhat straight there, Josh?
Yeah, that's pretty accurate representation. It's just in the case, in the trunk, or inaccessible from the passenger compartment was the way the law was created, and it was part of the penal code, which is quite different than the Medical Marijuana Act, which is in the public health code, and that kind of created that distinction between the two acts.
Now, if they had gone ahead and amended the Medical Marijuana Act to say that if you're going to be a patient and traveling with your marijuana, there will be a penalty if you don't have it in a certain spot, right? They could have done that, couldn't they?
They did. They could have, and they illustrated that when they went ahead and passed 4210 recently, which amended the Medical Marijuana Act. In that act, they correctly, I shouldn't say correctly, but they put it in the right spot, which would be when they made it a civil infraction to transport medibles without those medibles being, or what they call marijuana-infused products, but without those being in a trunk or in a case. That's now law as of just the other day.
So wait a minute. Wait. Let me just clarify, because I didn't know about this. If what you're saying is what I think you're saying, and let me reiterate. You're saying that the new law that they passed allowing for medibles does provide that they have to be in a certain spot when you're transporting medibles only. Is that
correct? It's the same language essentially from the improper transport statute. It's just this time it's in the Medical Marijuana Act, but it only refers to and applies to transporting marijuana-infused products, which are your medibles or topicals, that sort of thing.
Doesn't that tie the nuts of the police? Aren't they just twisted about this now because the legislature screwed this up in their eyes? They've got to be.
Yeah, certainly. I think that's going to prevent them from a lot of arrests that they've been doing. It's going to keep them from getting involved with searches, I think, in some cases. And I certainly think it was the legislature making a mistake. Although I think they knew what they were doing in some way, I don't think that at the time when they created the improper transport statute, they would have had the majority to amend the Medical Marijuana Act, because that would have required or opened up the door for other amendments which would have been added, but which would have not been as popular and wouldn't have got the three-quarters majority. It wasn't until they developed this new framework that they were able to get three-quarters majority to, I think, amend the Medical Marijuana Act more in a larger way, which now, like I said, includes the transporting medibles being a civil infraction.
Interesting. It seems to me that there would be some, I guess, reason for them to want to. What is going on with that now? See, now the phone that you're on is ringing. It's weird. I've never seen it do that before. It would seem to me that the legislature should have taken note of their own problem and at least double-dipped in the new statute, right? They did have a supermajority when they modified the law to say we're going to allow for medibles and we're going to create dispensaries and make this They were so busy salivating over the cash end of this, they forgot to button up the end they didn't like. Isn't that what happened here?
Well, yeah, I think they were, for some reason, confident, or I don't know why they didn't do that, because maybe they think the Court of Appeals wasn't going to grant my motion. I wonder that, because, yeah, like, they very easily could have criminalized the improper transporting of marijuana when they amended the act.
Right.
They made it a civil infraction for medibles, or at least what they could have done is made it a civil infraction.
Right.
I think they should have known that this wasn't going to stand up if they had done any case law research or looked at all into, like, People v. Kuhn, City of Wyoming versus Turbeek, Baraska versus Challenge Manufacturing Corp. Any of those cases have shown that the Medical Marijuana Act will trump inconsistent acts. And so this act clearly is inconsistent, and it's clearly a different act. So I think it may be what you're saying. They were just focused on the other parts, but at the same time, they were able to include a civil infraction for the transporting of medibles. Maybe what it was is that a lot of the legislators have smartened up a little bit, I guess, gotten a little bit wiser, and realized that they really shouldn't criminalize activity involving marijuana anymore, and decided to make it a civil infraction. I mean, that's what I can hope, at least.
Well, it would seem that that has to be what happened. I couldn't see somebody just dropped the ball there, because they knew they had to do this in order to do the medibles thing. They knew they had to have the supermajority. So it would only have made sense if they didn't have the supermajority when they did the transport law, that if they wanted to include it, all they had to do was lump it in and pass it along with the rest of the bills. It just seems crazy. We do have some. It looks like calls on the online. I don't trust them. I don't trust them at all. But let's find out if we've got a call there. Oh, there's no call there. Let's see if there's a call here. Hello, you're on the Full Melt Show.
Hey, Steve, it's Chad Morrow.
Hey, Chad, welcome to the program.
Hey, how you doing? Hey, I got a quick question on this for Josh, because I see a post here that I have another attorney friend of mine, and he's saying that with this, anybody that was convicted of a illegal transport can have or pled guilty, can have their conviction retroactively vacated now and get all their fines and costs recovered. I was wondering if that's true.
Did you hear that, Josh? Could you hear that question?
Yeah, I did. I don't know if the opinion goes that far. That's something I would like to see happen. In the opinion, they did seem to suggest that you have to be complying with the act. And so I think in some cases, if somebody had pled to an improper transport, but there was some other charge involved and it was part of a plea bargain, that might make that difficult.
Because they're intertwined. Because the deal's intertwined, right?
That could be part of it. And then another thing, if somebody just had an improper transport, I would certainly say if it was in the last 6 months, they were entitled to withdraw their plea. There is a Michigan court rule that allows you to withdraw a plea within 6 months if you have a defense to the charge, and I think now, based on this court opinion, you clearly have a defense to the charge. And so I think you could withdraw a guilty plea to improper transport. As far as overturning prior convictions, that's something, I mean, this appeal just came down today. Before I would say, definitively one way or another, that's something I want to look at. But I certainly hope that they've done the research and that they're right.
Did he answer your question, Chad? Do you have a follow-up, Chad? Chad, are you there?
Yeah, I'm here.
Do you have a follow-up? Did he answer your question?
No, absolutely. He did a fantastic job, and I just want to thank you for having me on, and thanks for answering my question, Josh.
No, for sure. Listen, in the future, if somebody gets, let's just say, do you think that there could be the possibility that people are going to be charged in the future with it? What happens if a local cop doesn't hear about this Court of Appeals case? How long does this take to get down to law enforcement before they stop charging people like this?
They do put out updates. I think that's more on like a monthly basis, and that depends on what the agency is. I know like Michigan State Police Department puts out monthly updates. I don't know about other agencies. I would certainly hope that's something they know about, and should take effect. It'll take effect right now. Certainly, any case pending. I would say any plea within the last 6 months, certainly, and so I think they won't be arresting people anymore. It may take, like you said, a little bit of time for that message to get out there. But if anybody does get charged with it, I think it's simply just showing the prosecuting attorney this opinion, and you will no longer be facing the charge if you're complying with Section 4 and Section 8 and all the other ways, and not violating Section 7.
248-278-8067 if you want to join the program. Josh, what about going forward? This is just a Court of Appeals' opinion, isn't it? Isn't there another step? Could the Attorney General appeal this to the state? Have they said anything about that?
I haven't heard anything about them taking it up to the Supreme Court. I see the opinion as being pretty much relying on People v. Kuhn, which is a Michigan Supreme Court case.
Right.
And I don't see how this is any different. So I would hope they could see that and not decide to take it up to the Supreme Court and waste everybody's time.
Right. I did take a look at the language of the opinion, and I thought it very interesting. A quote that they make, if I can find it here. There was it seemed like they quoted some. It seemed like something that I just want to repeat somewhere. I just got to find it now. It's down in the lower part here where they're talking about opinion. Nevertheless, courts are not narrowly minded bound by the labels given to an argument by a party, but rather by the substance thereof. They go on. Oh, where's it at here? I'm just looking for it. It's a little longer than I thought it was. Not defendant. So it's right towards the end.
There was also the dissenting opinion by O'Connell. And O'Connell usually writes in a pretty entertaining way, especially about medical marijuana cases. He had that entertaining opinion in People v. Redden, where he had one of the few court of appeals cases or opinions that I've ever read, or any appeal that I've ever read that had pictures in it. I don't know if people remember that opinion, but he wrote the dissenting opinion, and he had some pretty interesting things to say in that. He went as far as saying that he wouldn't have granted my appeal. He would have remanded it back to the district court to determine whether or not my client was in other ways complying with the Medical Marijuana Act. I think that in a lot of ways ignores the protections in Section 4 that says as long as you have your card and you're within the quantity limits, and they then will presume that you have medical use. And I don't see there was any allegations or any way they would have been able to overcome that presumption. But I think O'Connell's opinion was a little bit entertaining.
They wanted they talked about the prosecutor wanting here to treat it like alcohol, and that's where I thought the comment here was negative against the prosecutor, because the prosecutor wanted to equate this as an open transport law. They're like, this is the same thing as having alcohol. If you got alcohol and it's open in your vehicle, it's illegal. You can transport it in another way. You can not open it, but if it's open, it's illegal. And that's the same thing we got here. That's what his argument was. And they're saying, oh, no, that's a little bit different because we don't have a medical alcohol statute that says that you're not guilty if you're a patient. So what they said here in the opinion that I thought was interesting. It's actually amusing. It says neither scenario would affect the special status afforded to the marijuana possessed for medical purposes. And in fact, the illegal transportation of marijuana statute expressly refers to, quote, usable marijuana, end quote, under the MMA, rather than marijuana generally. In other words, if the legislature treated marijuana like alcohol, then the prosecutor's analogy to alcohol would make sense. It is manifestly apparent that a significant percentage of the population would like the legislature to do so, but that is not, at present, the state of the law. I think that's a very sharp angle back at the prosecutor, is it not?
Yeah, that was one of the arguments he presented at the oral arguments, and I think that ignores Section 4, that argument that it's no different than an open transport of alcohol. And I think that just completely ignores the protections provided in Section 4. There are no similar protections for alcohol. They're like the Court of Appeals stated there's no statute saying you can transport alcohol or possess alcohol in any way complying with the Alcohol Act and then can't be prosecuted. There's nothing like that. And so I think his argument certainly isn't genuine.
It says the illegal...
It's kind of grasping at straws.
It really is. It says, and with emphasis added, they're talking about, they're actually quoting a previous part of the opinion, but it says the illegal transportation of marijuana statute expressly refers to this provision and unambiguously seeks to place additional requirements on the transportation of medical marijuana beyond those imposed by the MMA. So what they're saying here is this is the same thing as People v. Wyoming, right? You can't make a law that's more narrow than the state statute.
Yes.
That's not modifying the Medical Marijuana Act.
That's completely... I'm a little bit disappointed they didn't address the constitutional argument, and then you'll notice that at the bottom of the opinion, that they declined to address whether or not the statute is even constitutional. I think if they had went as far as saying it wasn't constitutional, I think overturning past convictions would certainly be an easier process. Because obviously an unconstitutional law can't be something that remains on your criminal record that just wouldn't be, I don't think, American in any way. And they didn't address that because they found that my client was immune under Section 4. So that issue could be fought another day if people are in some strange scenario charged under an improper transport statute. And that's something I would look forward to doing. Because I certainly think it also violates Article 4, Section 25 in the way that it was done. And I think that's something the legislature is certainly aware of. I think that's why they were probably more likely to put the new medical provision in the Act, because of the way they did it the first time violated Article 4, Section 25.
At the end of the day, what does this mean for patients? You can keep your pot in your car wherever you want. Can you keep it on your person? Can it be in a cigarette pack? Can it be partially burned?
It can be anywhere in the car, as long as it's not medibles. As long as you have your appropriate amount of flour or extracts, you can certainly have those anywhere in your car that you deem appropriate, on your person, in the glove box, whatever. As far as it being partially burnt or not, that's not going to make any difference. The only thing that might do would be to raise some suspicion that you may be operating under the influence. I try to tell anybody that if you have contact with officers, bringing up your patient can be a difficult situation, because if you do that when you're driving, they quite often will jump to the when you're driving.
Josh, hang into that thought. We're going to break. Hold on.
You're getting the full melt.
Your pets aren't just animals, they're members of your family. That's why we are excitedly wagging our tail about our hemp-based product that caters specifically to your best friend. Hemp oil drops are great for aging as well as active dogs and cats, and really, all kinds of pets. Hemp well drops are made from virgin, cold-pressed organic hemp oil. Our extraction process ensures the highest quality oil for your pet, with superior taste, smell, and nutrition. We hold ourselves to the highest standards, never using heat, chemicals, or preservatives in making our hemp oil products for pets. Pick up a bottle of Hemp Well drops today at select retailers or online at hempwell.com. Hempwell, hemp health for pets.
Attention. Get ready to write down a very important number.
Michael does not know how to fail. second place is loser.
If you have a medical marijuana case and need legal representation, call the best, Attorney Michael Comorn.
He's very passionate in the courtroom.
Getting the best outcome requires quick legal action, and it needs to start with one call, toll-free to Attorney Michael Comorn. 800-656-3557. Write it down, 800-656-3557.
Michael Comorn gave us our life back.
Attorney Michael Comorn. Vigorous criminal defense.
Play-Doh compound can help kids practice communication skills. Start by presenting the visual of the letter or word. Then ask them to mold the Play-Doh compound into the shape of the letters. It's an effective way to foster speech and even writing.
Ram trucks are reaching new heights when it comes to capability and efficiency. The Ram Heavy Duty is the most capable full-size pickup on the road today. And the Ram 1500 is the most fuel-efficient full-size pickup ever. So what does that mean? It means Ram trucks are built for the long haul. Ram, America's longest-lasting pickups.
RootMetrics, in the nation's largest independent study, tested wireless performance across the country. Verizon won big with 153 state wins. AT&T got 38, Sprint got 2, and T-Mobile got 0. Verizon also won first in the U.S. for data, call, speed, and reliability. AT&T got text. Stuck on an average network? Join Verizon, and we'll cover your cost to switch.
It's the Full Melt Radio Show. We're talking with Attorney Josh Covert in Michigan about the Medical Marijuana Act and the transport law under which his client was charged this year. I think it was this year. Josh, was it this year that your client was charged, or was it last year?
Yeah, I think it was like 2014. It was a couple years ago.
Oh, okay. It takes a while to get to this stage, doesn't it?
It takes a while.
Don't you think that the Court of Appeals and the Supreme Court are tired of hearing about the Medical Marijuana Act? Aren't police and prosecutors fascinated with pushing these battles uphill?
I think they are. I don't know about the Court of Appeals. They seem to have no problem taking these cases and granting leave on them. If they didn't want to hear some of these, they could just deny leave. I think they grant leave on some of the prosecuting attorneys' appeals. Anyway, I don't know. The Supreme Court, I think, in the last opinion, Hartwick kind of said, like, hey, Court of Appeals, get this stuff right. We're sick of having to overturn you. And I think maybe this is a sign now that maybe they're starting to get right. They've kind of figured out. They had a chance to get Kuhn right, and they didn't get it right. And quite a few of the other cases. So I hope this, I'm always trying to be a positive optimist guy, and I'll take this as a sign that they're kind of coming around.
It seems like a message has been sent to what you're saying. The code of what Josh just said is the Supreme Court kind of said to the Court of Appeals, hey, handle this crap. We've given you enough to work with.
Yes. I think that was the message sent in Hartwick and Tuttle for sure.
If something does make its way back up to the Supreme Court, do you think it would be wrapped around the MMMA, or do you think it's going to be something else? Do you think there's still room for a Supreme Court decision to move up the chain?
Well, let's see how they decide on the probation issue. I know that's going to be argued by David Dudoy the first week in January.
Yes.
I originally had a case that was up at the Court of Appeals, and my client was terminated from probation successfully, so she was no longer able to continue with that. And then David's case was able to kind of join up with it, and so I'm real excited to see what he does. And I think if that doesn't go that way, of the patient's way, I certainly see that as being something that can get up to the Supreme Court, although the challenge there will be finding the right probationer that will be on probation long enough to see it through to the Supreme Court.
So you'd effectively have to be on probation for a couple of years, perhaps, up to...
Yeah, that's one of the challenges. That's what made it tough for my client to fight that at the Court of Appeals even. To get up to the Supreme Court would maybe be more of a challenge, but I could see there being some argument certainly be made if that doesn't go in the way for patients. Other than that, I think there's probably some more interpretation to be done. Overholt is pending leave, and I certainly think the Supreme Court grants leave in Overholt. Overholt was one of the Kent County dispensary cases where they're trying to assert a Section 8 defense for selling to someone unregistered to them. And I think that the Supreme Court should take that case. And I certainly think there are arguments to be made, and I think the act was intended to protect people in Section 8 from selling to someone that they're not registered to. I think that when they got the decision, really were completely wrong recently, and I hope to see that at the Supreme Court. So I think there's certainly room for that issue on the probation issue as well.
So you're saying that the first question that David Rideau is going to argue in January, early in January, is the idea of whether or not you can use cannabis while you're on probation. Is that the argument?
Yes.
Would that include probation,
parole, bond?
Okay, anything where you're not in the system, but you're not confined.
Correct, because that Section 7 says you can't use it in a correctional facility. I think that shows that the voters contemplated the effect the act would have on people in the criminal justice system and only excluded people in a correctional facility.
Wow. Okay, so
I think it's pretty simple.
Yes, and then the other argument, because it's important that patients, if you're a medical patient, you shouldn't be disafforded your opportunity to use your medicine while you're still pending a trial. Or even if you've gone through trial and you're now on probation for a criminal offense, that you should still not be misafforded your opportunity to use cannabis as a medicine. That's the question there. Then the other question you said is what now? With regard to
whether or not someone can assert a Section 8 defense, someone who's unregistered to them, a card holder that doesn't have your traditional transaction.
So,
selling, some card, maybe selling to someone else that has a card but isn't registered to the bud tender.
Right. Typically, the situation you'd have in a dispensary, dude.
Yeah, and whether or not Section 8 would apply to that. I certainly think Section 8 would apply to that type of transaction. The Court of Appeals has disagreed, and that's why that case is they're seeking leave to the Supreme Court. I've been waiting anxiously to see if the Supreme Court will grant that.
It seems like they should, because the question it really isn't settled law, is it? I mean, it would seem that the Medical Marijuana Act said, look, here's your venues. If you're a patient, you can grow it or get it from a caregiver. And if you've been caught with marijuana, you're immune from prosecution if you're within your limits set out within the Act. Or if you're not a registered patient or a registered caregiver, although you still have a card, I mean, you still have a doctor's note, right? You still need the doctor's note, yes?
Doctor's note, yep.
So as long as you've got your doctor's recommendation, that certification would still afford you a Section 8 defense, regardless of whether you've registered yourself with the state or not. And the question solved by the Supreme Court up until now, if you'll correct me if I'm wrong, has been about registered qualified patients and whether or not you're allowed to the big question that they've got is, hey, you're selling your overages. You're selling your overages to the dispensary or to another patient. He's not registered to you. The act was never meant for that. That's what their argument is, right?
Yep.
And the other argument would be that, look, the other angle that is afforded you as protection in the Medical Marijuana Act outside of Section 4 is Section 8, which says you don't have to be all you have to do is be a qualified patient. You don't have to be a registered patient, just a qualified patient, which means that doctor's note. And therefore, you should still be afforded protection too, and you're not limited to what's in Section 4. That's if you just don't want to be arrested or prosecuted. Now that you are being arrested or prosecuted, you're not held to those limits. So those limits would include selling outside of the registry. If you're selling to another patient that you're not connected to through the registry, he's still a qualified patient because he's got a certification from the doctor. The law allows for that transaction. The law allows for that parentage. It allows for that caregiving, because that's what it essentially is. And so, therefore, wouldn't that be an angle for dispensaries that are open now to still stay open, because we're serving unregistered patients?
Well, right now with the Court of Appeals, I mean, that's binding precedent that transaction isn't protected under Section 8, because they try to tie in, if I remember right, it's Section 6, some of the other obscure parts. It's strange. They're trying, like they did with the first cases, going way back to King and Kalanek, they're trying to tie together various parts of the Act to Section 8. And I think the Supreme Court said pretty clear that Section 8, the only other part that applies to it is Section 7, and whether or not you comply with those aspects. But the other parts don't, and they're now trying to tie together, like I said, they've amended it recently, and I think some of the numbers might have changed, but it was Section 6, and the definitions of certain words, or maybe it was the Section 3 definitions. But anyway, they're trying to tie other parts of the Act to Section 8, which I think Section 8 is pretty clear. You have to comply with the 3 elements of a Section 8 defense and not violate Section 7. If you do that, you're immune from a prosecution, and you're entitled to a not guilty if you were to go to trial with that affirmative defense. So,
because it is an affirmative defense. It's saying I'm guilty, but I have permission. Isn't that what an affirmative defense is? I'm guilty, but I got a reason. That's a legitimate excuse.
Yeah. I tell people that Section 8 with affirmative defense is very similar legally to affirmative defense and self-defense. Like in a murder case or some assaultive case, when somebody asserts self-defense, that's something they have to prove. You have to prove that, hey, look, this was self-defense. They don't just take you for your word for it or whatever. And if there's a question of fact, they're not sure if it was or not, that's when you go to trial and you have to, put up your case and say, look, this was self-defense. The affirmative defense in Section 8 is very similar legally to that type of a defense, where you have the burden to show that what you were doing was in fact reasonable, and you do that by showing the 3 elements of the Section 8 defense.
Are there a lot of people that fall in this category, like your client fell into? Are there a lot of people that get charged with a transport thing, and it's only a transport thing? It seems like there's probably a lot of it's various and sundry, isn't it? You get charged because you're not a patient, or you don't have your card with you, or you got a little bit too much, or maybe you had medibles before when there wasn't a medibles law, and then you're also additionally charged with the transport. So it's probably various.
People get charged solely just with improper transport all the time. Somebody asked me that today when I was doing an interview, and they asked me if I had to estimate how many people were had to go through this ordeal with an improper transport charge. And I would say thousands in the state of Michigan. I mean, the act's been around for quite a few years now, and when I'm in court, I see people all the time. I'm in courts all across the state, and I see people pleading guilty to improper transports all the time. And I mean, I know I've had quite a few cases myself. And I don't know how many people just went through and didn't even get a court-appointed attorney for an improper transport charge, because most judges won't give you a court-appointed attorney if they don't see jail as being one of the penalties for that type of charge, and most judges wouldn't on an improper transport charge. I've never even had a client do probation on an improper transport charge. But so many people, I think, just would go in and plead guilty right off the bat, not even ever get an attorney, not hire an attorney. And so, I can only imagine how many of these cases are out there. Like I said, I've seen quite a few in court, but I imagine so many of them are, go through the system pretty quick where I wouldn't even see it. I would say thousands of people have had to deal with this. I can only imagine how much money the state of Michigan has made off of bogus statutes.
There's really no metrics measurement here in the numbers going through the court system given a certain law, are there? There's no way to measure this because there's no censusing in the local courts. How can you tell how many people are charged in a given year with an improper transport charge?
I wouldn't know. I think I don't even know if you could get that through the Freedom of Information Act, because they're not required to create documents for you. I think that would be hard. I'm not real sure. I'm not aware of any way to find out how many people, but it's got to be a lot, because I know officers were looking for that all over the state of Michigan for the last couple of years.
Just to reiterate for people, if you get pulled over by a police officer, it's just a pullover because they didn't like your tail light, or something was the wrong color, or they didn't have a light over your. There's a lot of reasons they can pull you over. They thought they saw a crack in your windshield. You get pulled over. You don't think you were speeding or doing anything wrong. You got some marijuana in the car. You're a patient. Maybe you smell like marijuana because you just came from your grow, or you were just around people smoking. The cop comes up to the window. What do you do?
I tell people, if you know the car's going to smell like marijuana, the officer's going to smell it, giving your card may prevent them from searching, especially now that the improper transport statute gone away. But I still don't think that's necessarily going to prevent the search in all situations, and it may lead to suspicion that you're operating while intoxicated. So that's kind of a case-by-case basis for as far as I'm concerned, because I can see a little bit of risk no matter what you do in that situation.
Sure.
But I think if you don't think the officer's going to smell, because I know officers profile a lot. They'll say they smell it when we all know they didn't.
Right. Well, they'll use it as an open...
things are packaged and yeah, so if you don't think they can smell it, then there's no reason to ever pull out your card until they're putting cuffs on your back, because it's just going to create suspicion. But, if you're in a situation where you just went to a dispensary and you don't have to have it locked up anymore because of this new Court of Appeals case that you got to sit right next to you, it's probably a good idea to pull your card out right then and there and show them. If you've got a sack sitting right next to you, show them your card. If you've got your stash put away appropriately and you don't think the card's going to smell like marijuana, then don't tell them about your card. It's only going to raise suspicion for them to try to get you with operating under the influence, which is something I see a lot more of. I think that's a way officers are trying to compensate for increasing funds and that sort of thing.
It would seem to me that a lot of people have been given the advice, if especially if you think that something might smell in the car, or don't give the officer, even if something doesn't smell in the car, or you don't have any reason to believe that something smells in the car, don't give the officer an opportunity to claim odor. Don't give them the opportunity. So just crack the window, slide your driver's license registration through the window there, your proof of insurance, and wait for him to come back. Is that something that people maybe should do? Maybe deny the opportunity to use smell?
Any way you can keep smell down is a good idea. That's just going to raise suspicion. Now, you might be protected under possessing it because of the act, but that's not necessarily going to protect you if they think for some reason you're operating under the influence, which is certainly subjective in nature, and you don't want to be involved with having to defend yourself on a charge like that.
What if the police officer says, I want you to roll the window down because I want to talk to you? Can't we just talk through the window?
There's nothing wrong with that.
Okay. And so, but now he says, no, you either roll the window down or we're gonna open the door. Now what happens? I'm just trying to go through this as I would see it happen in my own eyes.
Yeah, pull out your cell phone, start recording, and then give me a call.
That's a good answer, Josh Covert. Let me give you an opportunity to plug your practice in your law firm.
Yeah, I work with the Nichols Law Firm. I'm a partner down here in East Lansing, and I also go by the Michigan Cannabis Defender on social media and that sort of thing. So you can check me out on Facebook, Twitter, and Mass Roots, all those types of things. And people can find you at the Nichols Law Firm. You got a number over there? 517-432-9000. My assistant's Letitia, and she can schedule anybody a time to come talk to me. I'm also doing right now a lot of different consults in regards to people that have questions about the new laws and want to talk about getting licenses when the applications come out here in 2018. Thank you so much, Josh Covert, for coming on and talking about this very important subject, and we'll talk to you very soon. We'll be right back with more news and information from the entertainment front coming up next.
You're getting the full melt.
And now, a Planet Green Trees flashback.
When do medibles have to be tested too? Is that also part of the caregiver?
No, that's only for the.
Will they have to be tested?
It's only for the dispensaries.
But there is a new restriction with respect to medibles in that patients can only make them for themselves.
Right.
And they've created new crimes for transfers outside of the caregiver.
They're very specific. I mean, it's not.
That's what we just talked about.
It's no more harsh than the manufacturer.
No. They can be transferred. The medibles can be transferred from the registered caregiver to the registered patient, but not beyond. And that's how they would expect you to interpret the law.
Don't miss the Planet Green Trees Show, Thursdays at 8 Eastern on Spreaker. Promotional consideration provided by NoSmell.com, pioneering the storage market for cannabis users. The NoSmell patented bag technology offers users 100% smell-proof detection from even the most sophisticated of noses. NoSmell.com, so nobody knows. When placing your order for a no-smell bag, make sure to use discount code FULLMELT and take 10% off the entire order. Learn more about no-smell technology at NoSmell.com.
Don't stop chasing, wander while the day brings up. Here comes the sunrise and we'll see the sunset. Coasting by the ocean with some music, turn it up. We got the whole night, 360 days of this. cure. That always make you smile.
Happiness is calling at sandiego.org.
When you need legal help, you don't want to guess at who's standing next to you in court. And when it comes to a medical marijuana defense, it's even smarter to partner with a lawyer before you need one. Based in Royal Oak, David Rudoy has a proven history of not being afraid to take your case all the way to the Supreme Court and win. Find the law offices of Rudoy Law
at RudoyLaw.com.
RudoyLaw.com is a quick reference on your rights concerning Michigan medical marijuana
and up-to-date news.
That's RUDOI Law.com. Call 248-935-9074 now and talk about your legal needs, because at RudoyLaw.com, we don't just stand up for you, we stand up with you.
My moderate to severe chronic plaque psoriasis made a simple trip to the grocery store anything but simple. So I had an important conversation with my dermatologist about Humira. He explained that Humira works inside my body to target and help block a specific source of inflammation that contributes to my symptoms. In clinical trials, most adults taking Humira were clear or almost clear, and many saw 75% and even 90% clearance in just 4 months.
Humira can lower your ability to fight infections, including tuberculosis. Serious, sometimes fatal infections and cancers, including lymphoma, have happened, as have blood, liver, and nervous system problems, serious allergic reactions, and new or worsening heart failure. Before treatment, get tested for TB. Tell your doctor if you've been to areas where certain fungal infections are common, and if you've had TB, hepatitis B, are prone to infections, or have flu-like symptoms or sores. Don't start Humira if you have an infection.
Ask about Humira, the #1 prescribed biologic by dermatologists. Clear skin is possible.
It's the Full Melt Radio Show.
Wow. I didn't know. I had no idea. The part that I had no idea about was the idea that you can't use your medical marijuana in the form of medibles and transport them if they're not out of reach of the passenger, inside the driving compartment. I guess it's within the. If you're driving alone, that would probably be wherever you can reach within the space of your driver's seat. So if you're in a car, you'd want to put that in the trunk. If you're in a truck, you'd want to put it out of reach of wherever you're at, like behind the seat, under the seat on the passenger side, back in the corner where you can't get to it from where you're at. This is what the law was in Michigan with the new transport law that was just overturned by the Court of Appeals. Saying now that you if you're a patient, you can still have your pot. You can still keep it in the ashtray. You can keep it in the glove compartment. You can keep it under the seat. You can keep it in full, plain, open view on the console if you wanted to. Nothing says, according to this Court of Appeals decision, as long as you're a patient and you don't have more than 2.5 ounces in Michigan, and you don't have, you don't have more than 5 patients, all that kind of stuff. You're within the. If you're a caregiver, if you got plants at home, they figure it out. Well, then they can, I don't. This is crazy. What it amounts to is that if you've got medical marijuana in the form of edibles or concentrates, now the concentrates themselves, you don't have to hide those. You don't have to put those in any particular place. The concentrates are now usable marijuana. So if your usable marijuana isn't in the form of an edible, a food product, then you can go ahead and have that wherever you want in the vehicle. Wait a minute. Does that cover oil? I think not. Oh, see, now I've got this question for Josh again. Because now I'm going to have to go up and look now. I'm going to have to go and look. Because he was talking about medibles. See, the new law that just kicked in isn't this law. There's 3 laws here that we're talking about. We're talking about the Michigan Medical Marijuana Act, the original law. And then they passed a separate, non-amending, just a regular separate driving law that says if you're a patient with a medical marijuana card and you've got marijuana in the car, you have to put it in a certain place or we're going to charge you with a transport violation, a misdemeanor. And then there's another law that is the new dispensary law. It's the new law that says you got to close down the old dispensaries. You got to get a license if you want one from the state. It's going to cost you a bunch of money. It's going to take you a couple of years to get one. We're not going to see those open until like 2018. But in the passage of that law, they also allowed medibles. They allowed for, and so the medibles themselves are required to be kept in a certain spot with this new law. But the old transport law that lumped, because medibles weren't allowed before under the old transport law. Those were illegal. They could just charge you with drug possession. You didn't have any possession protection for being charged. So now my question is, and this is a difficult needle to thread, which ones can you keep? I would say for safety's sake, until we can pick that apart for sure, keep your concentrates and your medibles in the place that the transport law says you got to keep them, in the trunk or out of reach. Keep them in a locked box, because then a locked box isn't within your reach, right? It's locked. The keys are on the keychain, which is attached to it's in the ignition. You're driving down the road, the keys are in the ignition, you can't get the keys to the box to unlock the box to get what's in the box. I mean, that would be the thought process. But for now, for the time being, it would be my advice, and I'm not an attorney, I can't give you advice, but what I would do is keep my medibles and my concentrates locked up. The bigger word is if you got some cannabis, if you got a bowl, if you've got a joint, if you got a blunt, whatever form of flower that you've got, it's in the car, it burned, it's partially burned, it's open, it's unopened, whatever form it is in. Currently, the Court of Appeals says that you're protected if you've got a card and you don't have too much, that you're protected from being charged. And I have a feeling the police are just fit-tied about that. How could they not be fit-tied about it? Because the whole idea here was to create a new place where the police could pick on you and get some money out of you. Because that's all it's about. If they really thought it was a problem with regards to a safety issue, then they would have charged you with a bigger crime. They would have made it a harder offense. In this instance, it's a 90-day misdemeanor that Josh Covert just explained to us on the radio, that there is no probable opportunity for the judge to look at jail time unless there are certain conditions attached as a possible outcome for a first-time offender. Most people that are getting charged with this are not going to be subject to jail time. It's going to be something you're going to get probation for. Or if you do get jail time, it'll be time served for whatever while they held you locked up while they were charging you before they'd call that time served. But if the outcome at the end of the trial is we have to take you back into custody, if there's room for that to happen, then you're not going to get. Then you're going to have an opportunity for a public defender. See, what Josh is saying is that if you're not in a situation where you can get possible jail time out of this, or at least the judge can concoct no method by which you're going to go to jail, even if you're found guilty of the crime you're charged, then he's likely not going to give you a public defender. If you need an attorney and you can't afford one, you're not going to get one under those circumstances, is what he just explained to us. So keep yourself safe for the time being as far as being charged goes, because it's never okay to operate while intoxicated. The question is, when does the state need to prove impairment? When does the state need to show that there's actual danger taking place here? The state would like to say, look, we don't ever have to prove that somebody's impaired. We just want to go with a certain fact, a certain number. Give us a target that we can find, and then everybody that hits that number is impaired. That's not the way it works anymore. They don't, they can do when you see them walking the line, you ever see anybody doing the sobriety check alongside the road? Touch your nose, lift your foot, walk the straight line, turn around and walk back, count forwards and backwards, say the alphabet, all that kind of stuff. That's when you're trying to establish that, hey, there were some balance issues, you weren't following directions, you couldn't touch your nose to your finger when your eyes were closed and your head was tipped back. Now there's some reason for the police officer to believe that, hey, we've got to investigate further to see if you're actually impaired. They don't want to do that anymore, because then they just give you a breath test and you're per se impaired when you hit 0.08. You're actually drunk driving at 0.08 here in this state. And I think impaired is at 0.6 now or 0.7. I don't know. Impaired is a little bit lower than that. But with cannabis, they've got no way to measure that amount. They've got no way to say whether you're impaired or not. So to me, if you're going to charge somebody with impairment with cannabis, I think you better walk the line. You better display some form of impairment. Otherwise, I don't think your charge should stick. These guys were looking for this improper transport law as a way of saying, hey, maybe we don't want to prove impairment. We don't even want to bring the question of impairment up. We just want to charge you because you've got pot where you can reach it, or you've got a partially burnt joint, or you've got a bowl in there. I can't even tell if the bowl's been lit on fire or not, but it's there, and you could be impaired. We don't even want to know. We don't care. We don't want your pot in your car. Today, things have changed in Michigan. Tomorrow, they may change again. I'm suggesting they're going to change all over the nation in the next 12 months. Mark my words on it. We'll see you tomorrow on The Full Melt Show.
The Full Melt Show is a production of TFM Media.